Welcome to the Probate Law Group show. I am Michael Koberlein, and I am here in Mesa, Arizona. Today we are going to be talking about probate law and what is a quiet title action in probate. The quiet title actions are typically going to involve a dispute over real estate, and when there's a dispute and there cannot be a consensus or an agreement reached, then you have people who decide that they want to go to court and let the judge decide whose property it is. And so that's what this discussion or this show today will be based on. We'll use the example of a guy named Joe. Joe still lives at home with his mom. He's 47 years old, and the deed of Joe's mother lists both him and his mom as owners. Joe thinks that when he dies, he automatically gets the home. Well, this may or may not be true. If Joe Bob and his mom own the home together as joint tenants with rights of survivorship, then he will get the home when his mother passes away. However, the result will likely be different if Joe does not have rights of survivorship, especially if Joe has siblings. So let's say that Joe doesn't have rights of survivorship, and let's say that Joe's mom dies without a will. Joe has 5 siblings, including Joe, and the state intestate laws direct that his mother's estate is to be divided equally among the living children. If that's the case, and Joe and his mother were only tenants in common, then Joe does not automatically get to keep the home. He could keep the home if he and his siblings decide that they want him to be able to do that. If they come to an agreement, then of course Joe can stay in the house. He can keep the home. He can do a lot of different things if he wants to. He can buy out their ownership in the home if he wants. But if his siblings do not want Joe to stay in the home and they would rather have the home sold and each get their share of the profits, they can do that. They can force the sale of the home. They can go into court and make that happen. In a situation like this, where his mother passed away intestate, Joe's family is likely going to have to go through the probate process. And so the probate process will likely involve, or could involve, a quiet title action in addition to the probate process, or it could be an estate partition is another phrase that could be something that people might, in Joe's situation, might decide to do. The reason that the estate would go through the probate process is because, and I'm just making an assumption here, but it's my hypothetical, so I can do that, that the house is worth more than $100,000, and the equity in the house exceeds $100,000. Arizona law says that if equity in the home or equity in real estate exceeds $100,000, then probate is required. And so in this situation, probate would be required because Joe's mom had equity of more than $100,000 in the house. the in the example that I shared with Joe, Joe's siblings decided to take him to court, and Joe hired an attorney, and he decided to go with Larry, the lawyer. And if Larry, the lawyer, mailed a letter to all of the siblings with a quitclaim deed and $5, and then waited 20 days for the siblings to sign those quitclaim deeds and send them back, then that is one way that they could resolve things. If his siblings decided that they weren't going to sign those quitclaim deeds, and if for some reason Joe really did have the priority interest in the home in its entirety, then not only would Joe get the house, but because of his lawyer's actions, he would also possibly get his attorney's fees paid for by his siblings. And at the same time, if that were a situation that were reversed, where Joe didn't get an attorney but his siblings did, and in this scenario that we talked about, that's the more likely case is that Joe would lose, because he was a tenant in common with his mother, and the interest that his mother had in the estate would split in equal parts among the surviving siblings. And if that were the case, then and Joe did not sign a deed that made them all, or that said basically that he owned a 50% share, and that his siblings, himself included, got a fifth of 50%, then their lawyers may possibly be able to collect their fees from Joe. Oftentimes, the scenario that I brought up can be a situation where a quiet title action can be filed. Other situations where an attorney may file a quiet title action could be a person signed a deed, but they didn't have the ability to consent. That would be a legal capacity argument. Another reason is there's competing claims for interest in the property. And again, that would be the scenario that I talked about with Joe. He and his siblings were competing for an interest in the real estate. Another reason is for people who have forged a deed. So they signed a name on a deed illegally, and in order to make it clear whose name should rightfully be on the title, people will hire attorneys, and they'll go to court and make sure that the title is correct, the deed is correct. If you have a situation like this, where you're in a legal battle or you're in a shouting match with siblings over property, and especially if it's in a situation where the assets are in probate, then and you weren't sure what to do next in this dispute, you can certainly give us a call at Probate Law Group. You can reach us at 480-535-8000, and we would be glad to talk to you. Thank you again for listening to the show today.